All right, get comfy, put your lighting out, catch your breath, and let's get this show on the road.
Show road.
Good evening. It's Sunday night, 8:30. Welcome to another live episode on Disqualified Dads. This is episode 80. And on this channel, we aim to help you through your family court journey. We provide emotional, mental, psychological, and support, of all sorts, to help you get through the meat grinder that is the family court. I am your host, Coach Farouk, and I am joined by none other than the best in the game. Barristers are scared of him. Judges hate him. Solicitors love him. But the fathers love him. It's none other than that family law guy. Give him a round of applause, guys.
Yes.
Give the brother a round of applause. Mr. Ryan. I would say this is the, first episode of 2026, is it?
This is the very first episode of 26.
Absolutely, guys. Episode 80. We've now done officially over 1 full year of live streaming once a week, every Sunday night, supporting fathers up and down the country. Right, Mr. Ryan, as scary as it is, I looked at my phone today, or my calendar, or whatever you want to call it, and it's 4th of Jan, and I'm thinking, hold on, just about entered January, 4 days in already, and I started thinking, hold on, am I on target? Am I doing what I've set out to do? Have I already fallen off my game plan? Has my New Year's resolutions already started crumbling? But the answer is no, guys. I'm still planning. I am still planning now what the next steps ahead are, and I am doubling down my efforts. We're going to be pushing it harder than ever. We're going all out. We're going all out, guys. Write your goals down. There's something about pen and paper. Actually, listen, I've got that book you sent me, that little handbook with the pen, really nice. I have to say, good quality.
There you go.
So
See,
guys,
I'll look after you, mate. I'll look after you.
If I had it here, I'd have showed you guys what it was. But guys, get yourself a pen and paper, little book and a paper,
get one,
and go through this exercise. I want you all to go through this exercise. I want you to write down your goals for 2026. I want you to write down what you want to achieve, what you want your life to look like, how you want to see yourself. I want you to write these things down, and I want you to read it every day. There's something about going through that process where you are brainwashing yourself, and then eventually you write down a game plan of how you're going to achieve it. Go on, show us the little handbook. The Mackenzie Pickard, That Family Law Guy handbook. Good quality.
There it is.
Nice, really good. It's good quality, I have to say. Thank you for that.
Beautiful.
I appreciate that, Mr. Ryan. Thank you. I mean, we've got a Disqualified Dads one that I've sent out to you. Did you receive the one I sent out for you?
Yes, I did.
Oh, great. Yes, I've sent loads out to many followers. I've sent many out there. I hope you've all received them. Yeah,
I'm
guys,
sure they have. I'm sure they have.
Anyway, Mr. Ryan, what's been going on? We're in January.
Anyway, right, let's get in. Let's get amongst it. You're right. It is the 4th of January, 2026. That's really quite worrying. But anyway, because before we know it, it'll be March, and then it'll be June, and then it'll be July. Before we know it, we're talking about heading back towards whatever, Diwali or Christmas or whatever. Obviously, Ramadan is around the corner. So the year will rush by the way years do. You and I have a lot of plans this year as to what we're going to be doing, what we're going to be up to. We are putting those plans in place as we speak.
Amen.
There are moves afoot in the background as to what's going to go on. So it's going to be a busy old year. Over and above all that, obviously, the day-to-day stuff still carries on. The family court still is the family court, and it still has a multitude of problems, and it still presents itself in not the greatest of ways to the parties within it. the week that we're about to head into, I'm in there every day, I think. Yeah, every day from memory. So the year is starting incredibly busily. I trust that everybody had a good holiday period, regardless of what you did in it, whether it was Christmas for you or whether you just had a bit of time off, whatever. But I trust everybody had a good holiday period, and I trust everybody had a good new year. Again, however you choose to spend it. Mine was in here, to be honest, in the office. Well, for all of the holiday period was in the office because we're incredibly busy at the moment. New Year's Eve, I watched it come in from this window that I've sat next to whilst I was doing some work. So yeah, but anyway, it is what it is. We are here now.
Absolutely. And like Mr. Ryan said, look, the year's going to fly by, but look, I don't want you guys to look at it like that. Don't count the time. Make the time count. Now, you might be heading towards, what this means is you might be heading towards every day that goes by closer to your children, to reuniting, to regaining contact, to rekindling your relationship with your child. The only thing, the most valuable thing you will have in this lifetime. However way you want to look at it, spiritually, mentally, financially, physically, in any paradigm you want to look at this, the most valuable thing you will have dear to you in a physical form and an emotional form, and I'll cut straight into your heart, is your child. And you might be heading towards your child. So we're going to make the time count, guys. And yes, on that note as well, there's grand plans. Another guy got in touch with me. He's good at admin. He's good at paperwork, very organized. He's interested in the McKenzie training plan. I said, look, I'm going to speak to Mr. Ryan. We got to get this going. And look, the day-to-day stuff. And listen, guys, I'm deadly serious. If you're good at paperwork, you're good at emails, you're good at talking to people, you think you could pick this up, you've been through your own family court journey, reach out to me. Don't email Mr. Ryan. He ain't going to get back to you. He's flooded. This is half the problem. He's just getting more and more email. He ain't getting back to you. Email me on disqualified.dads@gmail.com. And like I said to that brother, right, give me your name, details of address, where you live, ethnic background, religion, if you've done any sort of legal work, if you're good at paperwork, if you're good at admin, you're good at IT, write down all the skill sets you have. And like I said, I'm going to filter all of these through, sort these out. And then at some point, potentially even in January, I might head up down to Bandit Country, Measham, and listen, we need to get this McKenzie training program off the ground. We got a serious plan. There may be elements of guys you're going to have to obviously go through the training course ultimately, and then we might have to buddy you up with a currently working McKenzie, and you're going to have to start shadowing him through the court. We're going to have to come up with a game plan, but I'm now going to be pushing this hard so that, because the way things are going, I cannot see how we're going to keep on top of all of this. So guys, get on the program, get on the firm, be part of the machine that's going to change and help people out there. Join us, get behind us, get with us, and you can make a living out of it. It's flexible, self-employed, right? You do your own taxes, and CMS and all that, boys. You know how it is. You do your own taxes, limited company. I'll show you how to do that. I've even got a firm that can help you with all the accountant sides, guys. We'll help you set up. You work your own hours. You can work as hard or as little as you want. You could do it as a side gig. Ultimately, the passion has to be real. Can't just be about the money. You will make money. And I encourage people to make money, yeah? There's no shame and nothing wrong in making money. And you will be paid handsomely for your services. Yeah, it's a good living, guys. And the key factor is you'll be reuniting families. You'll be supporting fathers who have walked in your shoes. And in some cases, maybe even mothers. I'm deadly serious. Like I said, we're going to be inundated this year. So reach out to me. I'll put my email in the chat later. Disqualified.dads@gmail.com. Let's get this show on the road.
Amen to that. Amen to that. It is going to be a very busy year. And you're right. Excuse me. We are building a course for people who want to become McKenzie friends and do it the Picard way, which is the right way, which is the only way. So yes, we are building that course in order to show people how to do that. And we will provide for people the Picard vehicle that allows you to earn some money. But perhaps just as importantly, because that's why we do it. We don't do it just because of about the money. We do it because of what we do for people. So that's quite important.
Absolutely. Listen, guys, number one, right? Do not ever be ashamed to say that you're charging or earning. There's nothing wrong with earning money. A lot of working class people or the people that are not into serious money always have this idea where they have to justify why they need to. Brother, I love money. I love money. I'm putting that into the universe. I want it all to come towards me. I'm aiming for my Bentley, and I need you guys to get on board because I need to get this Bentley. Me and Mr. Ryan need to get this Bentley. When you travel up and down the country, we need to be doing speeches, seminars, gatherings, get on daytime TV, highlight all of this, expose this whole thing. And we need you guys on the front line taking up these cases in the courtroom. We need men. We need men. And we're going to do this, guys. We're going to do this. Right, Mr. Ryan, how do you want to proceed tonight? I know we keep talking about this trial and
yes, we're going to do trial, and again, I'm going to let the team down by the fact I haven't done any preparation for it at all because I've been so busy this week with some cases which have just blown up. So we're not, in a nutshell. We're going to just see what the world is saying to us. I can see some comments now, so let's just tackle those comments and see where it takes us. We will get to the fact finds, folks. We will do that. I apologise, it's not today. We've had a couple of the cases that have just gone into meltdown, and we've had to deal with that as a priority.
Right, Mr. Father's Rights. Guess what? He's on time. Well done. That's your New Year's resolution. Show up on time. Well done. Hey, guys, Happy New Year to everyone. I wish everyone all the best in our cases this year. Amen to that, my brother. Amen to that.
Yeah.
Inshallah. Right, Mr. Victor. Evening, gentlemen. I've got a court in 8 days, the start of the battle. Heads on and focused. Just need to work on my court Q&As and cross-examination. Absolutely, Victor. Get focused, knuckle down. I know you're in talks with Mr. Ryan, so reach out to him, get some pointers, do what you need to do, yeah? Drop him an email.
Yes, catch up with me this week.
Perfect. So that's Victor sorted. Sounds good for it, but income is income in terms of absolutely cost it. You're absolutely right. Income is income, guys. Do not think just because you're earning self-employed income or you've got a limited company that this is your opportunity to dodge CMS. How dare you? How dare any of you even think of that? How dare you? I am a proponent of CMS. CMS. Go CMS. I am a proponent of CMS. You all should be paid. If it was down to me, I'd have the full wages. 95% of your wages will be going to CMS, to the X. If I had my way, do you know what I mean? That's all I'm saying. That's all I'm saying. Mr. S, can we do the fact find role play today and all the traps and types of questions for fact find? Yes, I think we're trying to cover bits and bobs. Obviously, we haven't prepared.
We're going to have a chat about fact finds. Yes, we won't be completely disappointing. So in a minute, I will talk about the world of fact finding, and we'll wander around a bit and explore some of the pitfalls of fact finds.
Yeah. Before I tackle the next comment, right? You know, last week, right? I was freezing here. I had no heating. I said that. Yeah.
Oh yeah. Have you sorted that?
Well, this heating issue, right, it goes back to last Christmas. It's been going on since last winter, yeah? But obviously during the summer, because I didn't have the heating on, it somehow held the pressure. At least I had hot water. But like I said, the last few days, it was so cold. One night I was sitting there with a woolly hat on, jacket on. I went to bed. I was freezing. I woke up. It was bad, right, yeah? So again, pain pushes people to take action. And I sat there and I thought, all the stuff that I've done, all the engineering work I've done, obviously the thing is I didn't want to take the floor up and chop the floor out. I know where the leak is. I didn't want to I just can't have another unopened half-done job. So I thought, hold on. I thought there must be some fluid you can put in the system that'll just seal a little pinhole, yeah? Went online, mate, lo and behold, there's loads of this stuff. Got that, poured it in. Man, my whole life has changed. It feels like the last 2 days, my whole life has changed. I can't believe it's been going on for 2 years. And the heating has not been off. I've just got it on set on the stats, so it just cuts in and out. And the house has never been so consistently warm and on point. I've got to be honest, my whole life has changed. It just goes to show, do not procrastinate, guys. And if you've got a small pinhole leak, don't get a plumber or nothing, yeah? buy this bottle of liquid. It's I'll find out the name of it, whatever it was, leak sealer, 15 quid. Drain it down a little bit, pour it into one of the rads, run it for 24 hours. It'll seal a little pinhole. Job done. Hold the pressure. Boiler will stay in. All good. So I fixed that. Yes.
Now,
go on.
Before your time, because I appreciate there is a few years between you and I.
True.
When your radiator on your car was leaking, some people might remember this. You would put an egg into the radiator to seal a leak.
Really?
You just break an egg into the radiator to seal a leak. That was a classic quick fix.
Did it work?
Yeah, absolutely.
But how long did it hold for? How long did it hold?
Sometimes it would hold for just forever. You'd forget about it. That's it. It's done.
Okay. Wow. Fair enough. Listen, you learn something new every day. I remember that one. Right. Mr. Stephen Keeley. Right. Yeah, Mr. Stephen had some, obviously some issues over Christmas, as we know.
Yes.
Mr. Stephen, hope you had a good break. I'm preparing more letters to CAFCAS, social services, and the court to insist on a hair follicle test on the X. Also, I have a Section 7 on Wednesday. Any tips on that? All right.
Right. Let's talk about that first. When Stephen says he's got a Section 7, it means he's got his interview on Wednesday as part of a Section 7 investigation. Well, given obviously recent events, Stephen, and I'll leave it as vague as that. Wednesday is your opportunity. Wednesday is your opportunity to tell this story, because this story is a disgrace. So Wednesday is your opportunity, without coming across as malicious, without coming across as attacking or vindictive. Wednesday is your opportunity from your child's perspective to tell the story of what is going on here, and the concerns that you have. The key to interviews with CAFCAS is to be seen to come across as the reasonable one. Now, that doesn't mean that you can't make, obviously negative comments. It doesn't mean you can't make allegations, but you need to be seen to be reasonable rather than malicious. And there's a subtle difference there. I think you're absolutely right in terms of the hair follicle test on your particular matter. I think that's essential. And I think you need to make that point to CAFCAS, because they will carry that point forward on your behalf. And there is more weight in CAFCAS making that suggestion than there is in you. It is simple as that. So great opportunity coming your way to have a candid exchange with the CAFCAS officer and explain your concerns. Share with them what happened the other week. Absolutely share that with them. Share your concerns as to how that went down, because I am equally concerned as to how that went down. And just make your point. Make your point.
Yeah, Stephen, good luck, and keep fighting the good fight. Yeah, you're doing well. Right, Mr. S, shall we do a simple fact-find question type session? No need to put Mr. Ryan under pressure to prep so much. He is a natural.
Well, there is that. Come on, let's do a bit of fact-finding then. Okay, so before we carry on with the questions, all right, there are a number of very typical types of questioning that you are going to face in a fact find. You're going to face a question that we refer to as open, and you're going to face a question that we refer to as closed. Closed question means that essentially the counsel or the solicitor who is asking it is expecting yes or no, and that is all they're expecting, and they're very deliberately asking you a closed question to not give you any opportunity to say anything other than yes or no. Now, there are two ways to handle that. Number one, give them what they want, yes or no. Secondly, is to say, well, I'd like to answer that by giving you some context, and then off you go and tell the story that you want to tell. If the barrister is worth their salt, they will ask you, no, just answer the question yes or no. And you say, but the answer requires more than just yes or no. That's why I'm giving you more than just yes or no. So that's a closed question. An open question is where, tell us about something. And the reason they are giving you an open question is they want you to talk yourself into trouble. because people think, oh, great, this is my opportunity now. And I just spew and I just rabbit on and on and on and on and verbally vomit, and eventually get myself in trouble. So if you're handed an open question, tell us about this. What happened when, etc. Control yourself. Start by doing this. Breathe in, breathe out very slowly. Gather your thoughts. And
Count
then,
your Kit Kats.
yes, count your Kit Kats and then begin. Do not do, tell us about, well, yeah, that's what happened. This is that. Well, I did this and he did that, because what you're delivering is you're delivering reaction and you're not delivering a considered response. So every question you're asked, take the opportunity to just gather yourself. And if you need a bit of time, and these are some very quick tips, if you need a bit of time to think, because frankly, it's a tricky question, and it's a question that has the potential to land you in the crap, ask them to repeat the question. Tell them you don't understand the question. Could they rephrase the question? And that buys you just a little bit of time just to think about what it is that you're going to say, to ensure that you don't dig yourself a hole that you didn't mean to dig. What else is going to happen in the world of fact find? When the fact finds start, I'll tell you what happens in case nobody's been in one before or people aren't familiar. The judge will invite you to go and sit in the witness box, which invariably is halfway between him as a judge or her as a judge and everybody else. And in the witness box, you will find a copy of the bundle. So the bundle is the pack of documents that support every case. So you'll find a copy of the bundle sat there in order that you can consider it and you can refer to it in the questioning. You will also find probably 3, sometimes 2 of the holy books, because you are going to have to take an oath. And you have 2 options in terms of oath. You can either take on a holy book, so you can take it on the Quran, or you can take it on the Bible, or you can take it on the Torah, or you can take an affirmation. And an affirmation is just a statement that you intend to tell the truth, the whole truth, and nothing but the truth, etc., etc. But you have to take some sort of oath before you begin answering the questions under fact find or under cross-examination. Remember, the answers you are giving aren't for the benefit of anybody else in that room except the judge. It doesn't matter what anybody else thinks about your answers except the judge, because the only person in that room who has the authority and the power to make a decision that is going to impact your life is that judge. So eye contact with the judge. You're looking at the judge when you're giving your answer. I don't care how rude that appears to everybody else in the room. It's irrelevant. Eye contact with the judge. Pace yourself. Work with your Kit Kats. Think about what it is you're saying. There is no rush in court. Nobody's going to say, hurry up and give us your answer. Unless, of course, 10 minutes passes and you're still pondering. You are entitled to think. You are entitled to consider. You are entitled to make comments like, can you just give me a moment? Can you just rephrase that for me? Can you just ask that in a different way because I don't quite understand what it is you're getting at? You're entitled to make all those comments. Whilst cross-examination is theoretically a strenuous process and a nerve-wracking process, and it is to everybody. But at the end of the day, all it is an exchange of information. Or you are being asked a series of questions in order to provide information that clarifies a position for the judge. And if you think of it in those terms, you will answer in those terms. It is not a police interview. Nobody's going to get arrested. Nobody's going to get bustled into a cell and beaten up. None of that's going to happen. It is an exchange of information. The point of the questioning is to extract information from you. Your point in answering is to deliver your case so that the judge is aware of where you stand. Fact find.
Guys, I hope that helps. Make bullet points, write these things down. Like I said, we've repeated this many a times. And like I said, what we do is the message is not new. We just repeat it until it is fully drummed into you, becomes second nature. Your thought process works by itself, automatic. So, bullet point, write it down, read over these things again. And yes, I hope that helps. Oh, by the way, I watched Rocky 3 and 4.
You are living the Rocky dream currently. You are on the
Nah,
Rocky journey.
Rocky 4. No, I watched this was last week. Rocky 4. After the last stream, I just wrapped them up. Rocky 3 and 4. Rocky 4 for me is the best one. Originally, Drago, Russia, the whole thing. Rocky 4 is the best one.
Really? Which would just remind me, so it was Rocky 4 with Apollo Creed?
No, Rocky 4 is Drago, the Russian. What are you talking about?
Oh, the Russian guy. Okay.
Apollo Creed's 1 and 2. Number 3 is Mr. T. Number 4 is Drago.
Okay.
Listen, it was quality, man. And then I tell you what, I made a mistake. I even watched one of his newer versions of that Rocky series. I watched Rocky Balboa where he fights this young black fighter.
Yeah.
And I have to say, it was horrible, really. The whole
yeah, the new stuff, the new ones are dreadful.
You cannot replicate that same feeling of the original. I mean, it was bad. I mean, even the acting in the fight, like last fight scene, it just didn't. It was overacted. To me, it felt overacted. It just didn't seem right.
Yeah, there's an honesty in early Rocky films. Yes. There's an authenticity in early Rocky films. 1, 2, 3, 4 up to. I'm not a big fan of 4, but there's an authenticity to them. And as you get to whatever we are now, Rocky 17 or whatever we're on, they're dreadful. They're just dreadful.
Yeah. I'm sorry, I have to agree. But for me, look, Rocky 3 was good, but Rocky 4 special, man. Look, but the thing with Rocky 4 is this. Look, let me just elaborate on this. Yeah, if you look at all the soundtracks, if you look at Rocky himself, is a lot more polished. Everything's a lot more polished and presented, and you know the monster that. Think about this: when you look at Drago, and then you look at what he did to Apollo Creed, and then to say he says, "I'm going to fight him." You could potentially, everything he says. That line on the staircase with Adrian saying, "You can't win," and he's saying, "I'm going to be prepared to stand in front of him. I'm prepared to die." And he has to be prepared to, that whole scene. Listen, it's the same as Family Court, guys. You're up against this monster. It seems impossible. You just don't know how you're going to win. But guess what? To face that fear, to face those demons, to face that monster, that's what it is, man. This is everyday life. This is the Family Court journey. You need a heart to see this through, man. It's easy to give up. So for me, Rocky 4, the soundtracks, everything, the story, the whole lot, quality. I have to say. Anyway,
okay. No, that's fine. That's fine. No, that's fine. As I say, they do get worse as they get wherever we're up to now. They are horrible. But anyway.
Right, Mr. Father's Rights. I have a directions hearing on the 26th this month to decide whether a fact find is necessary. I have not received the respondent's sheet of allegations. The deadline for this was the 5th. Okay.
Now, do I assume that was the 5th of December rather than the 5th of January, which is tomorrow?
Well, that's a good question. How important are these deadlines? Can the respondent produce a list of allegations last minute? To be fair, I think she can, if I'm correct. They could delay the bundle to last minute. How would the judge view this? Some of the allegations are serious but lack evidence and are false. Okay, let me see if he's got commented further.
If there's any more, well, I start
5th of Jan. No, he's confirmed. 5th of Jan.
Tomorrow. 5th of Jan. There you go. That's tomorrow. That's tomorrow. So she's not late yet. It's tomorrow.
Okay, so she's not late yet, but the key is he's got an opportunity here, because ultimately what you want to do is try and completely brush the fact find under the carpet. You want to completely dodge it. Any tips we can give him to try and get this sidestepped completely?
Yeah, it's if you can. I mean, it's not easy. It's not easy. Certainly, if if you've got legal representation, you've got a solicitor with you, or you've got a barrister with you, or you've got a decent Mackenzie with you who can prep you a case. There is a legal argument for sidestepping a fact find, but it's quite a technical legal argument that revolves around a piece of case law called K versus K, which says that a fact find needs to be proportionate and it needs to be related to the children. The reason you need to do it is because it's related to the children. So it's quite a technical argument. So that's option one, is to have a decent technical argument around fact find and whether it should go ahead or not. But if there's any doubt as to whether it should or it shouldn't, the court will always come down on the side, well, we better do it. We better do it because rather get it right than get it wrong. So the skill with a fact find is, if you think and you know what your allegations are, we don't, or you know what they're likely to be. I know you're not theoretically going to get them until tomorrow, but you're pretty aware of what's going to happen. The skill is how you respond to those allegations. The more of those allegations that you can the more that you can dismantle, the better. Because then when you get to your directions hearing or PTR on the 26th, where the judge is deciding whether he thinks a fact find is necessary or not, if you've dismantled a number of those allegations, if you've said, well, look, I can demonstrate here and now that this is rubbish, that this didn't take place, or this has been exaggerated, or whatever the case may be, you can demonstrate that quite robustly to the judge. He will remove them. And there gets a point where if the allegations are down to one or two, the judge will say, well, I'm not running a fact find for one or two allegations. We'll deal with those in the normal run of these proceedings. I'm not sidestepping out in order to do a fact find. So that is the secret. That is the secret weapon in terms of trying to deal with the fact find. Is number one, very technical legal argument, but number two, try and dismantle as many of the allegations as you can in order that the judge is left with, do I want to run a fact find to deal with one allegation or two allegations or even three at a push? Do I want to do that and waste court time? No, I don't. So that's the skill set.
Yeah, remember, fact finds are dangerous for fathers.
They are. Well, fact finds are dangerous, full stop, because they're so unpredictable.
Right, Mr. M was meant to exchange witness statements. The solicitor didn't send across theirs, and I sent mine. PW protected.
Password protected.
Password protected. She made threats about raising costs and complaints to court, but any advice on this matter? This is a good question. I like this question.
Let's just break this down and make sure everybody's aware of what Emma's done here. So the way the court works is it gives a deadline and says, right, both parties will prepare a statement, a response, whatever it might be, and they will file an exchange. So what that means is that they will file it with the court, so send a copy to the court, but they will also exchange with each other in order that each of them knows what the other one is saying. That is your legal right to know what is being said. So, excuse me, exchanging statements between you and the other side is a game. It is a game because the way it's supposed to work is it's 4 o'clock on a particular day. I send you mine, you send me yours. That's it. Everybody's happy. It never works that way, because what happens is somebody wants to try and take the upper hand. So somebody wants to wait and let you send yours first, and then they want to have about anywhere between 5 minutes and half an hour of reading your statement before they send you theirs, in case they need to make amendments of theirs. So that's one of the tricks of the trade. So what you have done, Em, is a clever, which is you have sent your statement. So you have complied with the deadline, but you've put a password on it. So your stance in the court is, I sent my statement. I was told to send it at 4 o'clock on this day. I did. I password protected it because I was not convinced that the solicitor was going to extend the courtesy to me of extending their statement back. Consequently, I put a password on it. And as soon as I received their statement, I would then tell them what the password is, and that's it. Everybody's happy. And now it would appear that obviously what the solicitor has done is the solicitor has got miffed by the fact that you've been a clever dicky and done that to her. And now she's rambling about raising costs and complaints to the court. Ignore her. Just completely ignore her. It is hot air, and that is all it is. If she raises it in court, and let's be honest, the court isn't going to care less because it's trivial. If she raises it in court, your stance is a simple one. I had no confidence that the exchange was going to take place the way it should. So I sent my document and I put a password protection on it. And funnily enough, Judge, I was right because I didn't get her statement back. So I was kind of right, wasn't I? Shall we move on? That's where you are on it.
Yeah, I think everyone should take a note of that. I think that's a very smart move. And I think going forward, anyone who's got documents to send in, obviously at a deadline, and they can't, whether you can trust the other solicitor or not, I think password protected. Great strategy. I think we'll nick that one. Clever move. Everyone, make a note of that. Keep that up your sleeve. Right, Mr. Victor. One, kid's mum moved away without my knowledge, refusing to tell me what school our child goes to, and refuses to let me have a phone call or video call with them. Was told to speak to her solicitor. Oh, he's got a second one.
Put it down a bit. He's got another one.
Yeah. I have seen our kid in a contact center and got the report back. Do I ask in court about phone calls and lack of response from kids' mom trying to arrange calls, next contact session, school? 3, address plus the solicitor said it's a conflict of interest for her to answer me. Okay.
Well, that's a new one. So you've approached, we'll tackle these then, right? So you've approached her solicitor and said, I want to know the address where my children live. And her solicitor said it's a conflict of interest. What a load of rubbish. If she'd said, no, I'm not telling you, that's fine. That's perfectly.
No, he said it's a conflict of interest for her to answer him.
Yeah,
so for her to respond, it's a conflict of interest.
She is the solicitor representing the other party. It's her job to answer you. She doesn't have to tell you what you want to know. She's entitled to decline to tell you that, but she has to answer you. That's her job. What a load of rubbish. Anyway, moving on. So kids' mums moved away without your knowledge, refusing to tell you what school the children are at. Unfortunately, this is a matter, and V, this is a matter that's going to have to be carried into court at your next court hearing. And obviously you're there in whatever it was, 10 days, 8 days. You're going to have to raise it there. Because you're not going to get anything until you do.
I presume the same with this as well. Obviously, the school.
Same issue. Yeah, just raise the whole issue of the fact that the mother has taken a unilateral decision to remove the children to somewhere you do not know where, and that gives you a huge concern. Just raise it in the court and get the court to tackle it and direct on it.
Right, Mr. J, don't let them rush you in the call. Don't be afraid to ask them to slow down. To @Stephen from Mr. J. Presume that's for this CAFCAS section 7.
Yeah, true. Right,
Mr. A. Hi, both. RE section 7 report. CAFCAS has made a number of inaccuracies and refused to correct. I raised a SAR and requested corrections based on GDPR guideline. Worth exploring. Either you are at their mercy. Worth exploring, or are you at their mercy?
Section 7s often come with errors. You have the right to respond to a Section 7. So the approach I take is always twofold. My first approach is direct to CAFCAS, where I say, look, just letting you know, here's a series of errors that are in the report. and this is why they are errors, in my opinion. So that's the first thing you do. If you get no reply, and I guarantee you won't, you then put it within the response that you make to the Section 7, because you are entitled to lodge with the court a formal response to the Section 7. And in that, apart from saying, I disagree with this, I disagree with that, or I quite like this, I quite like that, you can say, there are a number of factual errors in the report, and here they are. And then you list them out.
There you go. Right, Mr. Stephen, thanks for the advice. I could tell when talking on the phone to Kafkas, they are trying to brush it under the carpet. So I'm digging into their own policies to push them on it. Also, X has stopped contact. Yeah, I mean, I was bound to happen. She was bound to fire some shots back there.
We knew that was going to happen.
Yeah. Right, Mr. S, if you feel the evidence is edited and not kosher, can you simply say you decline to answer on that basis?
You have to give your reasons. You can't just, no, I don't believe that, so I'm not answering. You have to give your rationale. So if somebody asks you a question and they're saying, based on whatever it is we're going to show you, this piece of evidence, you can say, well, I'm concerned about that piece of evidence, and here is why. And then you then relay whatever it is that you don't like about it. And that's how you answer the question.
Okay, that makes sense. Mr. S, Mr. Rivaldo, great work as usual, guys. I agree, bro. We are doing some great work. I'll take that. If the transcripts has many errors, how do you address this? Good question.
Okay, so transcript, again, just clarification for those who aren't familiar. Transcript is a written copy of what took place in a hearing. So you get, he said this, she said that, judge said this, they said that, they said this, said that. So it is where the audio recording, which is taken in every court hearing in family court, is recorded. So the audio recording is transcribed into a written document by a professional transcription company. There's about half a dozen who are authorized, licensed to work for the court. And they do sometimes come back with errors. And those errors come from either the fact that they've misheard what was said, or the audio is not very good, and so essentially they've made it up. But the way transcripts work is the audio recording goes to the transcript company. The transcript company do their first shot at it. It then goes back to the court and is checked by the judge whose hearing it was. And that judge is entitled, if they wish, to remove things from that transcript.
Great.
Because they don't believe that those things are relevant. So they can remove things from the transcript, and then the transcript comes out to you. If you have a view that the transcript contains errors, same as with the Kafkas report, first thing you do is go back to the transcript company and say, can you please check the recording? Here is what I believe are the errors, A, B, C, D, E, F, and G, or whatever they are. And secondly, you lodge with the court, depending on what you're using the transcript for, you lodge with the court, I have an issue with this transcript, here is what they are, A, B, C, D, and E, etc.
All right, I hope that answers the question. Right, Mr. L, if the ex-wife remarried, do I have the right to know where my child lives with her new person?
Providing there are no reasons why you shouldn't know, so there are no safeguarding issues, you're not in the middle of a domestic abuse matter, etc., etc. It's a straightforward, your wife's remarried, she's entitled to do that. She's moved to somewhere else, that happens, and she's living with a new husband. You are absolutely entitled, as I say, providing there's no reason why you can't, you are absolutely entitled to know where your child lives. That is your legal right, having parental responsibility for the child.
Right, Mr. D or Mrs. D, or I'm not sure. If you're applying to family court, does the court look to see if you have been in proceedings before with a different mother/father?
Yes, simple as that. The court looks at your full name, your date of birth, and checks you against court records. to see whether you have been in, because it doesn't matter who you've been with. They look to see whether you have been in court before.
Perfect. Mr. Father's right. Thanks for the advice. I'm taking notes. Guys, take note of what this man is saying. Take note of Mr. S taking notes. Mr. Farouk, I'm your guy you spoke to. Yes, Mr. M, I've gathered. Don't worry. We're going to fast track you. We're going to get you in the courts. We're going to get you representing. Don't worry. I've got your message. I'm going to pass it to Mr. Ryan. I'm going to have a chat with Mr. Ryan at some point this week where we're going to get a system together and get this moving because snowed under, bro. Snowed under. We got to start offloading. Mr. S or Mr. Father's right. Other than submitting a position to the court judge, will I have a chance to speak directly to the judge on the video link? If so, what kind of question am I allowed to ask?
If you're a litigant in person, i.e. you don't have any legal representation, then of course you'll be able to speak directly to the judge, and the judge will speak directly to you. If you have legal representation, it is usual that the judge will speak just to your representation. But occasionally, the judge may ask you directly a question. If you have something you specific, and this applies to everybody, whether you've got legal representation or not. If you have got something you specifically want to say to the judge, and that is absolutely your right. If you're on a video link, it's actually easier than if you're in the court, strangely. If you're on a video link, as we are now, so you can see what's happening. So here I am. I'm on a video link with the court. I've got something I want to say to the judge. What do? I do this. I don't say anything. Well, I just put my hand up. And the judge says, yes. And then you get to speak. What questions are you allowed to ask? You can ask anything that is relevant to your case. You can't ask him where he lives, but you can ask anything that is relevant to your case.
As I said, when you put your hand up like that, judge might think you're trying to say speak to the hand because the face ain't listening. I mean, you might take it the wrong way. Right?
There is that.
Yeah, so be careful with that. Do you know what I mean? Hand gestures, can be taken the wrong way. Right, Mr. M. But further to my question earlier about witness statements, can I use the fact that mom couldn't send her allegations across as reasons to get them thrown out? That's a good question.
If one side is supposed to make a schedule of allegations and they do not submit it, the stance that you take is a very simple one. The stance that you take with the court, and you do this in writing in a position statement ahead of the hearing, the other party has chosen not to take up their opportunity to submit a schedule of allegations. And so by virtue of that, I invite the court to conclude that there are no allegations.
Great. Perfect. Yeah, I think she might have done you a favor there. By the way, I just remembered 4th of January. So 4th of January 2016, my daughter, my second daughter, is this little one here, and I was born, and she's 10 today. So if she's watching, if she's watching this in the future, happy birthday. I'm here battling. We're pushing. Don't worry. It's all good. We will reunite. Stay cool. And remember all the lessons I taught you. And I love you and I miss you. Right, let's move on.
Amen.
Did you answer this one?
Yes, I did. Yes. Yeah.
Right, Mr. Victor. No, I've asked for a phone call with my daughter, not about the school. I think, yeah, she's playing. Look, she's playing up. When you get to your hearing in the next 7-8 days, you're gonna have to bring all of this up, Vic. You can keep pushing the solicitor. You can keep badgering the solicitor. There's nothing wrong with that. But can't see if you're not getting much luck. See that changing. Bring it up in court, but keep highlighting it to the solicitor. And if you've written emails to the solicitor demonstrating court, look, I politely requested via solicitor, politely, there you go, judge, they're not responding, blah, blah, blah. So like I said, log everything, build evidence. That's all we need. That's all we can do. Right, Mr. S, do you have to provide text screenshots or just downloads? Are downloads just fine?
Well, in terms of representing evidence, sorry, I'm just looking back to get a relevance to that statement.
Kind of meant transcripts of audio recordings being sent by other side. I don't know if that relates.
Okay, all right. So the transcript that you were talking about wasn't a court hearing. The transcript was an audio recording that the other side has submitted into court as evidence, and you've listened to the recording and read the transcript and decided that the two don't match. That's essentially what we're saying here. I assume it is. Right, okay. Going back to your previous question, evidence comes in 1,000 different forms. It can come in text screenshots, it can come in downloaded information, it can come in printed information, it comes in 1,000 different forms. They're all acceptable to the court, providing they can be read. Audio recordings, as I've just said, have to be transcribed to the court, primarily because the judge very rarely bothers to listen to them. They prefer to read what is said and then decide if there's any relevance in them bothering to need to listen. If your stance is that the transcript doesn't actually represent the audio recording, and that's a little sneaky little trick that sometimes is used when you want to downplay the audio recording. The audio recording's got some stuff in it you don't really want the judge to hear or indeed read. So you kind of skirt over it, or you reword it slightly, or you water it down a little bit. Yeah, you need to raise that in the court if that's your view.
Perfect. Right, Mr. P. Never had the ex's original recordings during my fact find. All metadata changed and recordings altered many times by merging files. Barrister didn't seem interested. Why? Any advice?
It's a difficult one. Just to say what P is talking about there. In court, you should be able to demonstrate the authenticity of an audio recording. So you should be able to use the metadata, which is the properties within a recording, to show the date it was recorded, the time it was recorded, and whether it has been edited or messed about with or revised. What people do, unfortunately, is they take the original recording and then they dupe it and they cut it and they dub it in order to clean out the metadata and get a completely different representation, very deliberately. So barrister doesn't seem interested. There is a very distinct possibility that the barrister didn't understand. I have been in too many hearings where we're talking about metadata and it's very apparent that half of the room don't know what we're talking about. Because it is quite technical. When you're talking about the technicality of removing core properties and source properties on a file, so it is technical. So that is issue number one. Possibly the barrister didn't understand. Why wasn't the barrister interested? Because they just weren't. Because it was a pursuit of it would potentially take them down a blind alley that they don't want to go down. Your stance, or anybody's stance, if they think an audio recording is not authentic, is to say to the court, I do not believe that this evidence is authentic. If when the metadata is checked, it doesn't tally, so we've got metadata that says the audio recording was made yesterday, when apparently it was supposed to be made 2 years ago, you can throw that question across the court and say, well, look, Judge, the onus is on the person submitting the evidence to demonstrate that it's authentic. We have an audio recording that allegedly was taken 2 years ago, but the metadata suggests that it was recorded yesterday as a result of various overdubs. I would suggest that throws it into question.
Good stuff. Very technical. Well, it may not be relevant as went against me. How long into the future can transcripts of fact find be obtained?
As in a fact find that's taken place previously, how long, how many years ahead can you claw it back? Yes. I can't give you a definitive answer. I can tell you the longest I have been in my personal sort of experience. I pulled down a transcript of a hearing that took place about 6 years ago. Yeah, 5 or 6 years ago, about a year ago. So it was sort of 5 years previous to when it is that I pulled it down. One of the biggest problems is the court is not very good at managing information. And there's a very, very, very distinct possibility. If you go to a court and say, I would like the audio recording of a hearing that took place 3 years ago, 4 years ago, 5 years ago, or longer, they are going to say, we haven't got it. We haven't got it. We don't know where it is, because they're not very good at keeping data. I had one not very recent. Well, it was fairly recent. I think it was October, September last year. I wanted a transcript, and I applied to the court. The hearing took place last February, so we're only talking 9 months later or 8 months later, and the court had already lost the audio file.
Great.
So we can't give you that because we don't know where the file is. Okay, well, that's just tremendous, isn't it? You know.
Well, I'm not surprised. I have to say. Right, Mr. or Mrs. D, I can't remember. Will the court be influenced, taken into account on previous proceedings a person has been in?
Yes, in a nutshell. Often the case that courts will consolidate proceedings. So they will often say at the start of a new set of proceedings, we will bring all the papers from the previous proceedings, wherever they might be, whatever they might be, into these proceedings. The only reason they won't do that is if the two people in the new proceedings are not the same two people who were in the previous proceedings. So if we're in a situation where you're in the court with a different other parent, and obviously that happens, we live in a real world, but you have been in the court previously with another parent, the court may still choose to consolidate some of the papers, but they will be a little bit more guarded because obviously they're now involving somebody who's no longer in the courtroom. What they will do is they will disclose those papers to CAFCAS. So CAFCAS will be allowed to see the previous papers in their entirety, unwashed, unredacted. They'll be able to see them in their entirety to see what happened in the previous proceedings. You may not get to see them if there's somebody else involved.
There you go, perfectly timed. That was the last question. And guys, this is my email, disqualified.dads@gmail.com. Hold on, we've got one more question, which I'll address in a minute. If you are interested in pursuing a career as a Mackenzie in 2026, please email me disqualified.dads@gmail.com. As mentioned earlier, name, sort of address, or where you live, where you're based in the country, ethnic background, religion, any skills like IT skills, organizational skills. If you're good at paperwork, you're good at speaking, any sort of attributes that you think may help, write it all down. Tell us what you do currently as well, so it gives us a good idea of where you're at. So yes, email me and we'll go through it and we'll get a system together, and I'll let you know what the next stage is if you're serious about it. Right, Mr. M, sorry, last one from me. How should I respond if mom's solicitor drops her allegations the night before responses to allegations are due? I expect some funny business. Will court care?
The court will care because the court's view will be that the mother, using your example, has wasted the court's time. Because the court has set a hearing. That hearing has decided that a schedule of allegations need to be produced, and it's gone to the trouble of directing that. It's then gone to the trouble of allocating another hearing to explore those allegations. If mother then just drops her allegations, the courts will be very, very unimpressed with that, because that is a waste of court time. It will play into your advantage, so don't be upset by it. Be welcomed by it, because your stance then in court is time's been wasted. This matter's been wasted. My children are being distressed and compromised as a result of what is going on here. I expect the court to act accordingly.
I'm highly shocked. Mothers wasting court times. Sorry, mothers wasting court's time. Never heard of it. Never heard of such things. Really? Mothers wasting court's time. Wow.
Well, you heard it here first.
Whatever next. False allegations. Adio. Whatever next. Right. I think that sort of wraps it up bang on time, lads. That was a perfect stream.
Come on, you've got 10 seconds to wrap it up. We hit the button.
Right. I've got nothing more to add other than happy birthday to my little girl once again. Any final comments, Mr. Ryan, before we close the show?
Oh, too late now. We've missed the mark.
Oh,
If you're in court this week, I trust it goes well for you. Respect the court, and the court will respect you. Keep plugging away. There's a new year. It's fresh. It's untouched. There's lots of virgin turf out there. Let's go and tread all over it.
Do you want to just quickly tackle this one from Mr. S?
Yeah, let's have a look.
What kinds of questions can I ask the judge that will appeal to their nature?
Appeal to their nature. When you ask questions, well, number one, it's very difficult to ask questions of judges because they will say, "I'm not here to answer your questions." That's not my job. But anything that you say to a judge, whether it's a question or a comment or whatever, try and ensure that as best you can, it is child focused.
Yes.
Try and ensure that I am saying this from the perspective of the children, from the best interests of the children, from the progression of the children. That's why I'm saying this. If the judge hears something that he thinks is just coming from you as a disgruntled parent, it's not going to please him.
Yeah, I think that reminds me the second commandment of the 10 commandments of family court: eyes on the prize. Have that filler in your mind. What do I want out of this? Is this child focused? Is this getting me closer to my child? Remember, eyes on the prize. Like, subscribe, follow, and share. And we will see you next Sunday, 8:30 for episode 81.